Paul Burke, Chief Executive Officer of the Northern Territory Cattlemen's Association.
Thank you.
And Tom Ryan, Executive Officer for the Northern Territory Cattlemen's Association.
Thank you. Yes, when you're ready.
First of all, I'd like to apologise for Tom Stockwell, the President of the Northern Territory Cattlemen's Association, who's unavailable today.
Sorry, thank you.
So I'd like to briefly read a statement and then work through the recommendations that were submitted and the alterations that we would like to see considered that we submitted last week. We've got a copy here for everyone that may make it easier to work through 120 recommendations, not that we want to change every single one.
You've referred to a submission that you put in last week?
Response to the draft.
Have you actually formally submitted that?
Yes, yes we have.
All right, well, we might chase that down because we haven't yet received it.
Okay,
so
we send it. We do have a copy
all right,
here.
well, if you've got a, yeah, absolutely, yeah, no, we haven't
Just
actually.
make it easier.
Yeah, no, thank you, but we haven't, perhaps if you could
recommendations.
try and resend it electronically, there's probably been a glitch in the system, but we haven't actually received it. Thank you.
So I might quickly read an opening statement.
Thank you very much. Yes, please.
On behalf of our members, we would like to thank the inquiry members for allowing the NTCA to speak to the scientific inquiry into hydraulic fracturing in the Northern Territory draft final report. We would also like to acknowledge the committee members for producing a balanced and detailed report. The committee has been inclusive and allowed all stakers to have considerable input. We have prepared copies of our detailed submissions that you have there. The NTCA is the peak primary industry body advocating for the Northern Territory cattlemen, an industry that we represent 90% of. The NTCA members are custodians of 700,000 square kilometres of the Northern Territory landmass and manage a herd of 2.1 million cattle. The NTCA is a grassroots organisation that unashamedly was founded to advance and protect the interests of the cattle industry. The NTCA has been engaged throughout this process. The NTCA Executive Committee formed a petroleum working group to advise the board in relation to gas extraction. Our membership has a wide range of views, and to say anything different would be false. We have battled through the process, but what we've endeavoured to do is keep our membership informed with detailed information that is accurate. Today we seek to give clarity in relation to our submission, the scientific inquiry into the hydraulic fracturing in the NT. The NTCA has taken a pragmatic approach to the gas industry, such that the gas industry is to proceed in the Northern Territory, then protections for the pastoral industry must be world's best practice and legislated. The key component of this approach has been to ensure that cohabitation can occur in a mutually respectful manner that mitigates interference on a pastoral lease. The fundamental view of the NTCA landholders is that whilst a pastoral lease does not have exclusive possession, they do have exclusive use for purpose prescribed of that lease. Any impact on that exclusive use should be compensated. Due to varying degrees of risks associated with each project and complex issues that will be unique from site to site and project to project, the NTCA considers individual rights critical to upholding the welfare of pastoralists and individual businesses. We maintain that the gas industry model in the Northern Territory must include the right to negotiate compensation for individual landholders, including the individual right of pastoralists to say no, or alternatively say yes. This right must be legislated. As perpetual leaseholders, NTCA members have the right of exclusive use to their land. Each landholder has the right to generally use the lease in accordance with the lease conditions without limitations. In any access agreement, the who, what and when must be defined in the detail prior to access being granted. The who is entering the property and how many people are entering the property. The what, a detailed scope of works including maps, locations and all relevant information. The when, what timeframes are involved exactly. And when will the works occur to allow for all parties to plan. To protect markets and customer confidence, both domestically and internationally, producers need to have full knowledge of what is happening on their property and when. Our ability to supply clean, safe and nutritious beef other than other agricultural products, the requirements for strict biosecurity safeguards, must be introduced to mitigate the impacts of increased activity on pastoral lands by the onshore gas industry. The NTCA recommends that prior to entry to a pastoral or agricultural property, onshore gas workers, contractors, must first complete an online biosecurity awareness module and receive a certificate or card acknowledging the completion of this. Prior to entry, any individual must provide this certificate to landholders. Entry can be denied by landholders to individuals that are unable to produce such documentation. The module will be developed and delivered by the pastoral industry in an online platform. It is recommended that land access agreements not include a confidentiality clause. Transparency is critical to the harmonised development of the gas industry and a cohesive shared land access arrangement. It is also important to note that land access arrangements across the mining activities should be harmonised, not just applied to the gas industry. And what we mean there is they should be for all mining interests, not just gas industries.
We can only, according to our terms of reference, look at onshore shale gas.
Understand.
Okay.
NTC is to be included in a Northern Territory government-funded gas tribunal, similar to the current land assessment panel. The gas tribunal should be established to deal with matters directly related to access by gas companies on private land. The gas tribunal must be endowed with such powers to direct compliance by both pastoralists and gas companies in relation to disputes arising in relation to land access arrangements. The tribunal's powers should be limited to disputes arising in relation to current and previous access arrangements, however, should not be constructed with powers related to decisions regarding compensation. The NTCA, as a key stakeholder in the legislative drafting process, is to be resourced by the Northern Territory Government to enable the NTCA to have informed input into the process through access to legal and expert advice when required. This will be critical in achieving strong legislation and regulation that is supported by industry and rural stakeholders. We will now work through our proposed amendments and refinements. If you have any questions, we're happy to take them throughout the presentation. It may be easier if you've got a specific question around a recommendation as we're talking to it. So, our responses to the recommendation. So 7.5, and everyone's got that document in front of them. The NTCA amendment, that change, that the use of all surface natural water resources, capturing overflow water, if agreeable to landholder, should be permitted. And it's probably just going to a little bit of clarification around that point. Recommendation 7.7. NTCA amendment include bore water flow rates as an additional measure of impact to ensure onshore shale gas industry does not cause unacceptable aquifer drawdown through the reduction of flow rates. Aquifer levels rise and fall naturally, so including flow rate of local bores will add another safeguard to complement the above-mentioned measurable. Bore flow rates are to be included in baseline data testing prior to exploration work commencing. 7.8. The NTCA amendment. The re-injection of wastewater is not supported unless an independent scientific review proves the feasibility and safety of water re-entering the system will not have a detrimental environmental effect or impact. 7.9. The NTCA amendment recommend including the volume of these chemicals. So in this one, we're talking about the amount of or the types of chemicals. We'd also like to see the volume of these chemicals and detailed advice on how they will be stored on site. Recommendation 7.11. NTCA amendment include a defined process to how on-site spills will be managed and rectified by a company. 7.13. The NTCA amendment. Similar to amendment recommendation in 7.8, the re-injection of wastewater is not supported unless an independent scientific review prove the feasibility and safety of water re-entering the system will not have a detrimental environmental impacts. 7.16. NTCA amendment changed to read that discharge of shale gas hydraulic fracturing wastewater, treated or untreated, to either drainage lines, waterways, temporary stream systems or water holes be strictly prohibited. 717. NTCA amendment, include the provision that any and all erosion created by any gas industry activity must be remediated immediately by the gas company responsible.
Okay, so just in the land section, recommendation 8.2 is just a suggested amendment to the wording to read that gas companies must have a dedicated weeds officer whose role is to monitor well pads, roads and pipeline corridors for weeds in consultation with the landholder. So that really just speaks to the burden, taking the burden off the pastoralists for weed monitoring in that situation. So 8.3 is a proposed amendment. As per amendment to recommendation 8.2, the recommendation should read very similar to have a weed management plan and a weed management officer in charge. And there's also the addition there that the plan must be consistent with all relevant statutory weed management plans and relevant threat abatement plans established under the EPBC Act. So 8.4 is a suggested amendment. We suggest adding a requirement stating that any fuel reduction burns will be conducted by or directly supervised by the landholder and will only be conducted under the landholder's express permission. Furthermore, gas exploration companies shall not impact on a pastoralist's ability to use fire for the purposes of environmental management, such as woody weed control. And just for clarification there, that's just so that the fire management plans of the explorer and the pastoralist aren't at cross purposes. So, as you know, fire is a very important part of land management, so we just don't want to get at cross purposes there. Recommendation 8.5 is a suggested amendment. Any impact on the pastoral land or its operations by monitoring, management or mitigation will result in the landholder being compensated in full. This includes any landholder time taken up by these activities and any disruption to the pastoral business's operations. 8.7 is a suggested amendment with the change to the wording suggested as that well pads and pipeline corridors be progressively regenerated with vegetation or ground cover established in consultation and agreement with the landholder. So just to clarify, that change there is around the native vegetation. So there may be, in a particular area that's been worked over by a gas company, there may be the ability for the pastoralist then to put improved pasture or something like that in there rather than the native vegetation back into it. So there's possibly the opportunity there. 8.8 is a suggested amendment, and this recommendation must stipulate that any environmental offset imposed does not detrimentally impact the affected landholder in any way and is fully compensatable to the landholder. 8.9, the suggested amendment to the wording so that it should read that the government consider the establishment and operation of local Aboriginal land ranger programs to undertake land conservation activities on Indigenous owned land only. The pastoralist reserves the right to choose a service provider to undertake any land conservation activities on the pastoral lease. 8.11 is an amendment to the wording, so basically change the word revegetated to regenerated. It's very similar to the previous recommendation, so amend it to read that corridor widths be kept to a minimum with pipelines and other linear infrastructure buried, except for necessary inspection points, and the disturbed ground be regenerated in consultation and agreement with the landholder to at least the standard existing immediately prior to any disturbance.
Yep. So 8.15. NTCA amendment, include additional restrictions stating well pads, pipelines and related gas infrastructure must not be constructed within 5,000 metres or 5 kilometres of reserved blocks unless expressly agreed by the landholder during access arrangement negotiation. Reserved blocks means land within 5 kilometres laterally of any of the following: a residence or dwelling, a schoolhouse, a classroom, a community, sporting or recreational building or purpose, a business, and so on, that are listed there. And the principal issue in relation to this is 5 kilometres on a pastoral estate is not very far. Living in a city, sounds tend to get lost in the other noises in the environment. When you're living on a pastoral estate and you're a long way from anywhere, the slightest sound can be heard for very long distances. So it will impact on people's livelihoods and quality of life as well if they're constantly hearing things that they haven't heard for generations. So we would strongly urge that 5 kilometres be considered. Recommendation 10.3, similar to the previous, we're actually talking about offset distances, or that 5 kilometres is a suitable amount of distance on a pastoral estate that can be many thousands of square kilometres. And that's what we're talking about in there with the reserve blocks. Recommendation 11.3. The NTCA strongly opposes this recommendation and recommends that it be removed. We currently think there is enough legislation to be able to afford the right protections without additional ones over a pastoral estate. And a pastoral estate should be able to be in a position where they can discuss and actually move through a native title process if they require. So we think it's over and above what's currently in place. Recommendation 12.3. NTCA amend, remove local councils from this recommendation. Most of the NT road network is administered by the NT government. And in most cases, the NT government is responsible for funding and maintaining those roads. 12.5. The NTCA amendment include provision for suitable land being made available within towns free of native title for purposes of subdivision to allow for future development. We see this as a real opportunity to grow some of the towns by having freehold blocks, and that includes all of the areas within the proposed development. 12.6. NTCA amendment recommendation should be amended to state that in consultation with local communities, Aboriginal land councils, local governments, the governments and pastoralists, gas companies be required to identify suitable accommodation, whether temporary or permanent, which must be completed prior to the construction development phase. Given a lot of what will be happening will be on pastoral leases, we see that the pastoralist may wish to engage with a gas company for the purposes of providing accommodation or providing facilities. And we just like pastoralists added in to that section.
So recommendation 12.9 is a proposed amendment to add a point referring to a landholder's time. So, for example, when a landholder is engaged in any activities in relation to gas exploration and is taken away from normal operation and life on the land, that the time expended on these gas activities be compensatable. So 12.10 is another amendment. This recommendation in its present form ignores the fact that pastoralists are part of the community. So any consultation involving community is to include all landholders, including the pastoralists. So there are several recommendations that are very similar with the amendments that we've made, where we're just asking for pastoralists to be included in those lists of stakeholders. Recommendation 12.11 is the same, to include pastoralists within community. 12.12 is the same. We'd just like to be included in that list of stakeholders. Now, moving to the economic impact section on recommendation 13.3. So the amendment that we've proposed is to include provision that any employment or service provision resulting from onshore gas development occurring on a pastoral lease be offered in the first instance to the affected landholder. So as Paul stated before in one of the previous recommendations there, given that most of this work is going to be carried out on pastoral lease, there may be significant opportunities there for the pastoralist to provide services to that company. And we feel it appropriate that the landholder in that situation be at least offered the first opportunity to engage in those activities. Under regulatory reform, recommendation 14.4 is an amendment. Now this relates back to the inclusion of clarification of the reserve blocks. So you'll note that we've included a lot of in those definition of a reserve block, station buildings such as homesteads, yards, waters, that kind of thing. 14.6. So the amendment that we've proposed there is a change in the wording. So a statutory land access agreement, and sorry, I'll just clarify, this goes to the heart of our submission. A statutory land access agreement to be developed by a working group comprised of the NTCA executive, gas industry representative, NT government representative, that provides standard minimum protection for pastoralists. Further terms negotiated between the pastoralists and the gas company may be included as special condition as to the statutory land access agreement. The parties to determine whether the special conditions take precedent to the standard terms of the statutory land access agreement. And so further to the recommendation, the NTCA should receive government funding to resource its participation in this working group to ensure that we are adequately resourced to take part with meaningful and informed input.
14.7, the NTCA amendment, remove mandatory minimum, amend to read that the government implement a compensation scheme payable to all pastoral lessees affected by the petroleum and gas exploration. What we don't want to see is, by having minimum referred to all of the time, that becomes the norm and nothing's paid above the minimum. We would like some safety nets in there, but there's an ability to be able to negotiate above what the standard minimums are. So just having some flexibility within the decision-making process. Recommendation 14.8, the NTCA amend to read that the government should implement a royalty payment scheme to compensate pastoral lessees for all new petroleum fields brought into production. 14.9, the NTCA amendment that only persons directly affected by proposed grant of exploration permit may lodge an objection. What we don't want to see is pastoralists going through a stressful period negotiating with gas companies, and then for it constantly to be going through a court process or going through an appeal process and not understanding or not knowing where they're going to be from day to day. So they would like the ability to be able to see the people directly involved in the process at the table. 14.11, so that the Minister must not grant an exploration permit unless satisfied that a gas company is a fit and proper person, taking into account, among other things, the company's environmental history, the history of compliance with the Petroleum Act and other relevant petroleum legislation, and its financial capacity to fully remediate in a timely manner any adverse environmental or otherwise impacts caused by its operation. That the Minister's reasons for determining whether or not a gas company is fit and proper person be published. 14.26, and we are nearly finished. A lot of these were simply smaller wording changes too. The NTCA supports a reduction in the regulatory fees for such companies, but not a reduction in monitoring.
So 14.29, the proposed amendment is just to remove the word consider from that statement. So we propose that it reads that the government enact provisions that reverse the onus of proof or create rebuttal presumptions for pollution and environmental harm offences for all regulated onshore gas activities. 14.32, the proposed amendment is that the NTCA recommends that reforms described in option 1 be implemented and agrees with this recommendation on this basis. The NTCA does not agree with option 2 being implemented.
That concludes our recommendations from the draft report. The NTCA have provided a detailed submission to the draft report, but would like to reiterate that water, both quality and quantity, issues remain the priority for the pastoral industry. The other key area addressed through our submission is in the form of legislated land access agreements with built-in safety nets to protect the grazing industry. In summary, the NTCA supports the scientific review and its process and has provided detailed feedback with additional amendments and refinements and wishes to remain engaged with the process. Happy to take any questions?
Yeah, yes, absolutely. I think we'll start with Dr. Ritchie.
Thank you. Thank you, Mr. Burke. And I guess the thrust of your submission is that you support a number of changes to laws and regulations to address that imbalance that occurs really because of the fact that the tenure of a pastoral lease does not give your members any rights below the ground, and it does give them to gas companies, and that can cause problems. I guess I'm a bit at a loss to understand then that the only recommendation that you strongly object to is one that's about the rights of somebody else under the ground, and that's in 11.3. You strongly oppose, and I just reiterate, it's the only one you actually say strongly oppose, and it really, I can't see how it changes anything for your members.
I guess working through with the petroleum working group, the risk was that it coming over into the pastoral sector and implementing or implicating what we actually do on the property as well, to have significant scrutiny, extra scrutiny on our property and the way we operate our business, grade fence lines, put in fire breaks, all of those type of issues. We just saw it was over and above what's currently in place.
This
I
is
think
to
you'd have
protect
to
sacred
elaborate on that,
sites.
because
We certainly support sacred sites and we support the Sacred Site Act. We strongly support the Sacred Site Act and the ability.
But can I just, that already, we'll come to this in the next question, but about the 13.3. But the pastoral lease has the rights that you have for a pastoral lease, and which also sort of sit over the non-exclusive title, which is native title. Native title has the right to protect sacred sites, within the limits of the law being the Sacred Sites Act. That already has significant implications for your industry, and over the last 30 odd years, there's been kind of I would say very high degree of working through all those things and resolving those issues, and sometimes your members go through formal processes of authority certificates, but most usually it's done directly with the traditional owners on properties, with the owners of the properties. I just don't see how, in fact I'd like you to explain why you think this would make any difference to those arrangements that have been in place for 30 or 40 years. So
I'd also like to note that the Northern Territory and the pastoral industry in the Northern Territory has led the way in a lot of the native title negotiations that have happened. Most have happened through agreement. We've managed to work through a significant amount of those, and I think there's another 17 listed for next year for going through. So the subsurface water is an interesting conundrum. We access the sub water. We certainly have no issue with what's above the ground. Water is a right for us to take for stock and domestic, and we just believe that having another level of legislation or of regulation over that water that we're talking about under the ground would put some impediments on a or potentially could put some impediments on a grazing business. Okay, and I'll just read you that this is we had this from Santos this morning that they put to us that it's the committed to protecting sacred sites. It's the traditional owners who determine where exploration can take place without impacting sacred sites, both above and below the ground. And I guess the point is that we've picked up this recommendation from representations from Aboriginal traditional owners and custodians. There is some
support from the actual industry itself. And I guess by having it so, the strongly bit particularly in yours would put you at odds with a group that you've actually had very, very good relationships with. And have you considered I guess that there is there's that potential that you're saying, that worrying about groundwater, but it seems a very strong way of
I'm happy to take it on notice and provide a detailed response to your question.
Okay, thank you. Can I just go quickly to 13.3, where you talk about landowners? I'm assuming that when you mean landowners, that includes native title holders.
Of course.
Yep.
Of course.
Thank you.
Thank you. Yes, Dr. Anderson.
Just a quick question about the recommendation relating to weeds, and the recommendation includes one of having a dedicated weeds officer, and my understanding is you support that, and you just asked for consultation with the
Correct.
department.
So what we're actually asking is...
So we've had feedback from industry expressing concern about mandating a dedicated weed officer, and so my question to you is, to what extent do you think it is really important to have a dedicated weed officer?
So a dedicated weed officer may look over multiple sites. We're not talking an exclusive resource for each individual well or each individual development. What we're saying is we would like to see someone that is dedicated to that area of work, that is available to a pastoralist to contact at ease. So if there's an outbreak of weed in a certain area, it makes it easy to contact. You've got one point of reference, but also that in the process of any land management plans or weed management plans, that it's in consultation with the landholder, and we support that.
It also gives assurance, I guess, that there is that capacity of mitigating the weed risk within that company, that company operating on the land does have the knowledge and capacity to be able to put an effective weed management plan in place, given that weeds are a pretty significant risk in terms of if they get away, it does leave a significant legacy issue. So.
I had a couple of questions. The first one was in relation to 14.7. I'm going to say the intent behind that recommendation was to do precisely what I think you've argued for, which is to provide a base level of protection, and then negotiations can be had above that base level. So I would have thought by removing the words mandatory minimum, you're in fact weakening substantially that recommendation. Is that what you wanted to achieve?
So what we wanted to achieve was to have a safety net in there, but if people are able to negotiate a better outcome, that can also happen.
That was certainly the intent. Mandatory minimum, I think you can substitute for
Correct.
a baseline safety net.
Yes.
So in light of that explanation, do you wish to amend what you say about recommendation 14.7?
Take that on notice if I can.
Thank you. All right. The other thing was, I think you've recommended against confidentiality clauses, or at least amendments around the recommendation concerning confidentiality clauses. Again, that recommendation was framed in a way to allow people flexibility in their negotiations. Indeed, we have had some, there's been some feedback that in fact it may well be for reasons entirely appropriate to that individual or individual sort of pastoralist that they want confidentiality. Why shouldn't that be permitted if that's what the landholder wants?
So you're absolutely right. We would like to see the ability for a landholder to make that decision. So if a landholder would like to talk to his next door neighbour about the deal that he's managed to be able to negotiate, then he should have the right to do that, as opposed to have a total confidentiality agreement that precludes him from talking with his neighbours about what he's negotiated within his or her access.
But that's what the recommendation, with great respect, says. It allows, basically, I think it says that there should be no confidentiality unless it's mutually agreed between the parties. So you would, again, do you want to revise what you say in relation to that recommendation?
Again, I'll take that on notice.
Okay. And then finally, you have argued against option 2, and I'm very much curious as to why. Option 2 was the option that proposes a wholly separate statutorily created regulator. That regulator would also have incorporated in it something along the lines of the gas tribunal that you have proposed, which would effectively allow a separate independent arbitrator to deal with those types of claims, deal with enforcement, deal with compliance, basically take this out of the hands of politicians. So what are your objections to option 2, so I can, this is quite important, so I can understand that properly?
Sorry, what page are you on there?
I'm recommendation,
1432.
it's page 33, your response to recommendation 14.32.
Sorry, 14, yep. Yeah, I don't have the report in front of me. I've got a summary of the recommendations. I can't read what those wordings are, option 1 and option 2 here. I've just got a summary of what we reported.
I would certainly, we would very much like to know what your objections is with option 2, because again, the view of the panel was that option 2 was in fact the creation of, as I said, a stronger, more independent body that would afford greater independence and therefore greater protection to the community, and by the community I include yourself, TOs, everybody. So I really do need to know sooner rather than later what
don't
your...
have that.
Yep, no, that's fine. It's not
in front of me.
it's not a quiz by any means. But
No.
we would really, that's quite important. We'd really like to know because most of the feedback we've had to date, admittedly we're only week 2, day 2, has been that people the community quite likes option 2. So if you don't, we would like to very much know why.
Understand.
Thank you. All right. Yes, Professor Hart.
Just a question on 7.5, recommendation 7.5. I don't quite understand what you're getting at there. I can certainly understand the idea of capturing overland flow. I must say I'm doubtful as to why the gas industry would want to do that, given that they're in, particularly in Beetaloo, evaporation rates of 2+ metres a year. What are you getting at there?
So the opportunity that the pastoralists saw there was the opportunity that if dam infrastructure was to be put in to capture that overflow water, there may be an opportunity to utilise that in the future in a pastoral operation sense. So the way that was worded within the recommendation was there was no capture of water or no taking of water, I think, from natural watercourses. So the ability for us to be able to capture water and have a future water storage may be advantageous for the pastoral industry into the future.
But you still have that opportunity.
We do.
To do that.
We do.
You're suggesting that the gas companies might do that.
In some cases, they may want to.
And you want the capacity after that to utilise it.
Yeah, and in some cases, they may or may not choose to do that.
I just don't see it, but I understand where you're coming from.
Yeah.
Thank you.
Yes, Dr. Jones.
I'd like to explore some aspects of recommendation 8.15, which essentially refers to a 5,000 metre radius of reserve blocks as an offset. I can understand why residences, perhaps, and some of these other things fall into that category. I'm just looking at this, the dot point, which refers to specifically to artesian wells, bores, dams, etc. Now, a 5 kilometre offset in a radius around one of those would effectively amount to a 10 kilometre diameter situation. Now, we visited the Beetaloo station, for example, and there they've actually put in watering points that are quite closely spaced. You should probably be aware. So, if a 5,000 metre radius was to be enforced around each of those bores, you'd probably, just from memory of their current plan, you'd probably cover the entire pastoral lease. So I just raise that in that context, and also in the context that we're recommending a 1 kilometre offset from an existing stock watering or domestic watering bores from the point of view of a spatial separation to allow for the cautionary principle for any impact.
So critically, the 5 kilometres relates to houses, stockyards and areas of work. The inclusion of bores was around mustering periods, was around certain times. It was difficult to differentiate between different pieces of infrastructure, and that would be certainly something that could be negotiated as part of an individual access agreement.
Okay, well, as long as it's a negotiable point rather than it being a mandatory, I think not just from the scientific point of view, but also from the practicality point of view, it could cause some issues.
Yeah. Well, our sole objective is to be able to cohabitate if we go down this path, and the ability to be able to continue to run our business as we've done in the past with minimum disruption. So.
Okay, so maybe it needs a little bit of qualification, perhaps. Maybe you could come back to us on that one, saying that this is a sort of an operational window, for example, as you're talking about mustering, rather than it being a in perpetuity exclusion zone.
Correct.
Yes, Professor Priestley.
Yeah, I presume a similar rationale applies to your recommendation 10.3, where you've proposed the extension of the setback distance for health reasons from 1,600 metres to 5,000 metres. That 1,600 metres was based upon an analysis of the published literature that's contained in that chapter, and I can only assume that the 5,000 metres that you propose there is to be consistent with other parts of the recommendation, and it's based primarily on the amenity issue.
Correct, but you can't have an offset of 5 kilometres for one recommendation and not have it consistent with the second one. Otherwise, you know, which one do you actually go by? Is it the 1.6 kilometres or is it the 5 kilometres? So it was to create consistency.
Any further questions? All right, gentlemen, thank you for your presentation. And
Thank you very much.
I must say, the panel certainly appreciates you going through in detail the recommendations and making your comments in relation to those. That's very useful.
And we'll provide feedback in the next couple of days.
As soon as possible would be good. Thank you
Thank
very
you.
much. Yes.